Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. So, this is an update on Megan Thee Stallion's case. She sued Milagro Elizabeth Cooper, aka MilagroGramz, pretty much for defamation, cyberbullying, you name it, she sued her for it. And since then, Megan had updated her amended complaint, and Milagro ended up filing another motion to dismiss, claiming that what Megan Thee Stallion was saying was defamatory wasn't actually defamatory. And so there was a number of things that were mentioned in the motion to dismiss that was filed recently. And Megan has since then filed an opposition to Milagro's motion to dismiss. So let's hop right on into it. All right, so it shows that this document was actually filed on yesterday, and it says plaintiffs Megan Pete's opposition to defendant Milagro Elizabeth Cooper motion to dismiss. So while we're getting into this, y'all make sure that y'all definitely hit that like button. Don't forget to share and also subscribe. I try to cover all types of cases, whether non-celebrity or celebrity, to just kind of keep you guys entertained on what's going on in the legal world of some of these people out here in the world. So definitely hit that like button. But let's hop right on into this. So Megan puts as her preliminary statement. So Megan Pete brought this action to end the onslaught of malicious and defamatory lies defendant Milagro Cooper has proliferated across the internet through her social media accounts, and to recover for the damage that defendant has caused to Miss Pete's personal and professional reputation. As alleged in the First Amendment complaint, defendant had undertaken a smear campaign in apparent coordination with Daystar Peterson, aka Tory Lanez, a convicted felon who violently pow-powed Miss Pete. As we all know, and now when I say she, Megan Thee Stallion actually was granted a 5-year restraining order against Daystar Peterson, aka Tory Lanez. He cannot contact her directly or indirectly use any type of third party to get in contact with her, harass her in any type of way. He cannot be in within 100 feet of her. Even in his not probation, he's eligible for parole, I believe, sometime in 2029. And this particular restraining order ends May of 2000, no, actually January 9th, 2030. So it does protect her for 5 years. Now, there has been a history where he has violated protective order, gag orders, and previous restraining orders. Thus, the reason why I believe was a large factor in determining that she was her to be granted that restraining order. All right, but going back to this, with Mr. Peterson behind bars and now recently subject to a court order restraining order, defendant is doing his bidding by telling the world that Miss Pete lied about him pow-powing her and defaming Miss Pete not only as a liar or perjurer, but also as someone who is mentally incapacitated, in need of a guardianship, and suffers from alcoholism. And just like they stated previously in Milagro's motion to dismiss, what they were saying is that they were using hyperboles. These were figure of speeches. It's not saying that she's incapacitated or she suffers from this and this. If the shoe fits, then wear it type of situation. Worse still, defendant has taken other despicable measures to intimidate, harass, and cause injury to Miss Pete, such by promoting an artificial pornographic video falsely depicting Miss Pete in sexual activity. This case is not brought uh this case is not about the right to express opinions, because that's what they were stressing in the motion to dismiss, on a criminal trial, or a plaintiff's attempt to silence opinions she disagrees with, despite what the motion to dismiss would have the court to believe. Instead, it is about a malicious smear campaign undertaken for the sole purpose of harming Miss Pete in retaliation for her defiance of a violent criminal. Plaintiff agrees that anyone in America is entitled to comment on public trials, Plaintiff does not agree, though, that this country permits repeatedly and falsely accusing a crime victim of giving perjurious testimony under oath about whether her assailant pow-powed her. Indeed, it is Hornbook law that it is a defamatory assertion of fact, not a non actionable opinion of or hyperbole, to make such assertions. Yet defendant's motion clinically pretends as if in trials rarely is there something that is absolutely true. So she must have cartel blanche to call Miss Pete a liar. Let me see, and that was in the motion at paragraph 6. All right, so the post-truth world defendant thinks she lives in is not reality. Whether Mr. Peterson pow Miss Pete is verifiable. I'm gonna read that again. Whether Mr. Peterson pow Miss Pete is verifiable. Whether Miss Pete told the truth about pow-powing was verified by a unanimous jury verdict. Defendant has made false assertions of fact, and the First Amendment does not protect her malicious speech. For the reasons described below or discussed below, the First Amendment complaint states a claim for each cause of action on which Ms. Pete seeks to recover. Defendant's motion should be denied. So here's the statement of facts. Megan Pete is a performing artist known as Megan the Stallion. First Amendment complaint that was filed. Da, 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 da. Now, defendant Milagro Elizabeth Cooper is a social media personality that owns and operates various social media accounts with over 100,000 followers. Defendant has publicly admitted that she is not a journalist. Daystar Peterson is a performing artist known as Tory Lanez. On the evening of July 12, 2020, Mr. Peterson pow-powed Ms. Pagan with a pow-pow, causing her to suffer injuries to her feet, necessitating medical treatment. The Los Angeles County District Office later indicted Mr. Peterson on charges of felony assault with a semi-automatic firearm. His trial began on December 12, 2022. Ms. Pete testified that Mr. Peterson pow-powed her. On December 23rd, 2022, the jury returned a unanimous guilty verdict, finding Mr. Peterson guilty of all 3 felony charges brought against him. Mr. Peterson is currently serving a 10-year prison sentence in California. Throughout the trial and to the present, defendant has engaged in a campaign of harassment against Ms. Pete based on defendant's let me see, conspiratorial relationship with Mr. Peterson and his father, and they're going to be known as the Petersons throughout this complaint or this motion. Defendant's smear campaign includes spreading false and disproven theories that Mr. Peterson did not pow Miss Pete and that Miss Pete did not suffer pow wounds as a result. Based on her conspiratorial relationship with the Petersons, defendant made a series of repeated defamatory statements against Miss Pete that one accused Miss Pete of lying under oath and perjuring herself at the trial. Two, falsely claimed Miss Pete is legally retarded and requires a guardian. And three, condemned Miss Pete as an alcoholic. Defendant's defamatory statements are false statements of fact reasonably understood to attribute to Ms. Pete the action or conduct described herein. Defendant knew or should have known that these statements were false. For example, defendant admitted that defendant admitted that evidence from the trial that she had claimed had gone missing was in fact in police possession. I'm going to repeat that again. Defendant MilagroGramz admitted, and it is in court records on the docket, she admitted that the evidence from the trial that she had claimed was gone missing was in fact in the police possession. So, for everybody out there who was not aware, she actually put that in a court document that she admitted that the item was in police custody. Defendant spread her defamatory statements out of a disdain for Ms. Pete as a means to gain notoriety and due to financial incentive from the Petersons. In addition to her defamatory statements, defendant promoted a altered visual depiction of Ms. Pete. On June 8, 2024, defendant liked an X post that featured the video. By liking the post, the video became displayed on defendant X account's likes page, which tracked and displayed liked posts for other users to see. So what they're saying is I'm not sure if anybody knows how Twitter works, but when you like something, there's you have let me see, you have like your main tweets, and then you have your mentions, and then replies, and then your likes. So when you like a video or a picture, whatever the case, it's going to go in that likes section. So that's what they're incorporating here. That same day, defendant made an X post that directed and encouraged her social media followers to go to my likes so they could see the deep fake video. Defendant confirmed that she drew attention to deep fake video and told her followers to view it, which caused the deep fake video to gain popularity. So now we're going to discuss the legal standards. To survive a federal rule of civil procedure motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And then they cited Ashcroft and Iqbal. A pleading withstands a motion to dismiss if it alleges factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. When considering a motion to dismiss, a court must construe the complaint in a light most favorable to the plaintiff and take the factual allegations as true. Here's the argument. Ms. Pete states a claim for defamation because in MilagroGramz motion to dismiss, she's saying that she didn't state a claim for defamation. In that motion, Milagro also cited Florida Statute Section 770.001, in which Megan's attorney is now saying that that statute does not apply because Milagro is not a media defendant. All right, she's just an individual. She's not a world star hip hop or or I wouldn't even say that. She's not TMZ. She's not the news. ABC, NBC, CNN, MSNBC, Fox News. She's not a media defendant. Milagro was sued, not her company. Milagro was. All right, so Section 770.01 Florida statutes requires pre-suit notice and defamation actions against media defendants. Because remember, they were talking about, well, she should have sent a cease and desist letter. Nothing was sent. Blase, blase, blase. Once again, that statute is against in regards to media defendants. Defendant has admitted to not being a media defendant. She's not a journalist. Stating definitively she is not a journalist. Oh, I just said that. As a result, that section does not apply to this case. Defendant has the burden to show that she is a media defendant, and her one paragraph argument fails to do so. The statute requires notice only where the case involves a publication or a broadcast of libel or slander in a newspaper, periodical, or other medium. Section 770.01 of the Florida statute states that Florida courts have consistently interpreted Section 770.01 to apply only to news media, for example, the press. They cited case Mazzara Ospina, where it says that the statute's other medium language is limited to news media defendants who publish statements via an other medium and does not expand to reach of the statute beyond the news media. Thus, every Florida court that has considered the question has concluded that the pre-suit notice requires only to media defendants, not private individuals. All right, I see you, Meg's attorney. Shout out to Quinn Emanuel. Oh wait, I don't know. I lied. I don't think Quinn Emanuel is helping her on this one. That was in her restraining order case. I got to see who the attorney is. In general, media defendants are those individuals engaged in the dissemination of news and information throughout the news and broadcast media. They cited Siri and Axoy. um, Says a court's focus remains on the content of the digital publication and the central issue of whether it could be likened to the kind of content newspapers, broadcasters, and periodicals publish, because that is all that sections 770.01 and point zero two encompass. Defendant has the burden to demonstrate she is a media defendant. Let me see. She fails to point to any allegations that support her conclusory assertion that she is a social media blogger who regularly live streams and posts about current topics, including celebrities and the hip hop community, which is insufficient to how she is a media defendant in any event. While she cites to paragraph 12 of the First Amendment complaint, nothing in the allegation supports that claim. Because defendant has failed to meet her burden, the court should reject this argument. So, Milagro stated that she is not a journalist. Therefore, she cannot use that Florida statute because it only um, refers to the news media, like I said, journalists. All right. So if you're not a journalist for CNN, MSNBC, Fox News, TMZ, it's not going to work out for you. You cannot use this. So Megan's attorney is pretty much saying that do not dismiss this case based off of this statute because it doesn't even apply to Milagro, who is just an individual. Moreover, nothing in the First Amendment complaint is sufficient to support a finding on a motion to dismiss that defendant's social media channels are akin to news media, and the First Amendment complaint allegations show that defendant is, in fact, not a media defendant. The First Amendment complaint alleges that defendant is a social media personality who has publicly admitted that she is not a journalist, and she is therefore a private individual rather than a media defendant. The First Amendment complaint also contains extensive allegations that defendant is a hired pow pow for Mr. Peterson and has conspired with the Petersons to use her social media accounts to execute a widespread campaign to maliciously injure Ms. Pete's reputation and inflict severe emotional distress upon her in retaliation for her testimony regarding Mr. Peterson's unlawful act of pow pow violence against her. Allegations that defendant used her social media accounts to harm Ms. Pete are sufficient to defeat her unsubstantiated contention, and she is a media defendant. Plaintiff authorities are inapposite and distinguishable in any event. Defendant mischaracterizes comments in Van Voris as involving a blogger with a YouTube channel, but it actually was a World Press blog, not a YouTube channel. The case wasn't an appeal from the decision on a summary judgment record, not a motion to dismiss. So that's crazy because they miscited a case. They had a case, but obviously I don't think that they read the case thoroughly. Because if they did, Milagro, oh, it isn't the what is that firm that is working with Tory Lanez? I forgot what the name of it. They are the ones that's supposed to be helping her or representing her through this case. Y'all got to get it together. All right, so the case that they cited but didn't really brief it, it says that case was an appeal from a decision on a summary judgment record, not a motion to dismiss. That record included testimony that the defendant founded the blog entitled Public Intellectual in order to publicly comment on an issue of public concern in an intellectual manner, which is absent here. And the court was careful to note that it was not prepared to say that all blogs and all bloggers would qualify for protection of section 770.01. Likewise, in I think it's Girl Power LLC versus Rodriguez, I remember they cited that as well in that motion to dismiss. It says that the court found the defendant YouTube blogger to be a media defendant primarily because there was no indication that she is editorializing on behalf of a client. Huh. Let me see. Here, however, Ms. Pete alleges that the defendant conducted her campaign of harassment as a paid surrogate of Mr. Peterson, who is still on Mr. Peterson's payroll. In other words, to the extent defendant argues she's engaging in editorializing, she does so on behalf of a commissioning client, Mr. Peterson, removing her from the realm of disinterested and neutral commentary or editorializing reserved for media defendants. Simply put, defendant is a malicious actor, not a legitimate news media outlet entitled to the protection of 770.01, and her motion under that section should be denied. Oh, this is the one I'm looking for. Defendant's statements are not opinions or rhetorical hyperboles. And that was something that she stated in the motion to dismiss. Milagro did. She's saying that these are just extreme exaggerations. If you believe it, if you believe you are, then that's, who am I to stop you from believing that? But that's just my opinion. That's just my extreme exaggeration. So the First Amendment complaint alleges that the defendant maliciously published numerous false assertions of a factual nature designed to destroy Ms. Pete's reputation. Defendant's attempt to cast her numerous false assertions of facts as mere opinions and rhetorical hyperbole do not square with the law of defamation. Where a court first determines the statements are susceptible to a defamatory interpretation, factual questions arise that should be resolved by the trier of fact. They did Trump versus, oh, that's good. They cited Trump versus Broad Companies. And this is actually the case where Trump, hold on, let me get some water. Trump actually won this defamatory case, y'all. And ABC had to pay Trump, but since he is president elect, he the funds that he would normally get for the judgment is actually going to charity. But Trump actually won his defamation case. So I'm excited that they cited this in here. That's crazy. Anywho's, so they cited Trump versus ABC. And they state if the statement is revealed to be confusing or ambiguous, raising the question of whether readers might have read it in a defamatory way, a jury question is presented. Where a reasonable jury could conclude plaintiff was defamed, dismissal is inappropriate. So if we are reading this, let's say it went to court. No, we ain't even gotta say that. If you and I are reading it, but it all determines because there's like a split of people who like Megan and people who don't like Megan. And I'm pretty sure people who don't like Megan, y'all gonna read it in a totally different way. But like when I was reading, some of the things, I'm like, this to me, it does seem as if it is defamatory. I'm not gonna lie. And that's not just because I like Megan Thee Stallion, but I'm not like really deep into, what's going on. So I'm just kind of, if I read something and it doesn't sound right, I'm gonna be like, it doesn't sound right. So when she is saying these things, when Milagro is saying these things, and as I'm reading it, to me, yes, I feel that those are defamatory. So if you have 6 to 12 jurors that are sitting in a room and they're trying to determine, you know, is this defamatory? How are they going to read it? So in this Trump case, obviously they didn't get to trial, but they got to the point where the question was this defamatory? If people read it, does it seem hurtful in any type of way? I was shocked. Trust me, I was shocked because I like Trump won this. Then I went back and read it, and I'm not a Trump fan, but I can see why he won it. Um, an opinion, unlike a statement of fact, is incapable of the quality of truth or falsity. However, a statement that, although ostensibly in the form of an opinion, implies the allegation of undisclosed defamatory facts as the basis for opinion is actionable. Thus, a mixed expression of opinion is not constitutionally protected. Further, where the speaker or writer neglects to provide an audience with an adequate factual foundation prior to engaging in the offending discourse, liability may arise. Even if a speaker states the facts upon which he bases his opinion, if those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact. Simply couching such statements in terms of opinion does not dispel these implications. In Milkovich versus Loran, they state where the court finds that the statement in question is of mixed opinion, in fact, and reasonable, capable of defamatory interpretation, then a jury issue is presented. A defendant contending that her statements are rhetorical hyperbole must demonstrate that the alleged defamatory statements are the sort of loose figurative language that no reasonable person would believe presented facts. Let's see. Then it breaks it down. Defamatory statements accusing Miss Pete of lying under oath are false assertion of fact because we all know. Let me just read it. I'm gonna keep my opinions to myself. Defendant's defamatory statements asserted that Miss Pete lied under oath when she testified that Mr. Peterson pow-powed her are false assertions of fact. Mr. Peterson was tried and convicted for the crime of pow-powing Miss Pete. Defendant's contention that her statements are non-actionable opinions because defendant's testimony at trial cannot be proven true or false given the different narratives is fallacious. Whether Mr. Peterson pow-powed Miss Pete is verifiable and has been verified by a court of law. Stating that Miss Pete lied about him pow-powing her is therefore verifiable and can be proven false. Tellingly, defendant fails to cite a single authority supporting her argument that it is an opinion or hyperbole to say someone perjured herself at trial. That is because the law is definitively to the contrary. In fact, defendant misleadingly cites Turner versus Wells, a case that contradicts her own argument. So once again, the attorney for Milagro messed up again. The Turner Court observed one can determine with resort to empirical proof whether a plaintiff perjured himself in a judicial proceeding. Indeed, in Milkovich, the Supreme Court held that the connotation that petitioner committed perjury is sufficiently factual to be susceptible of being proved true or false based on a core objective evidence and is certainly verifiable with evidence adduced from transcripts and witnesses presented at the hearing. Numerous other cases have held similarly as it pertains to both perjury and telling lies more generally. In Blake versus Gustibly, it says affirming the defamation judgment for plaintiff and holding that statements accusing plaintiff of lying about the fees are factual allegations and the evidence showed that they were false. In Pearson versus the National Institute for Lab, it says denying motion to dismiss where defendants accuse plaintiff of lying to the court because such accusations are neither constitutionally protected opinion nor rhetorical hyperbole because they are capable of being proven false. They also cite McNamee or McName versus Clemens, where it says Clemens statements that McName is a liar are facts capable of being proven true or false by a determination of whether or not McName in fact injected Clemens with steroids. The statement can be proven true or false by either truthful testimony or conclusive evidence. And then here we go, another Trump case, Carroll versus Trump, affirming defamation judgment where defendant said plaintiff is not telling the truth and is a liar. And if y'all all know, Carroll actually won that suit against Trump, and he has yet to pay her. Defendant's attempts to transform her statements into opinions by parsing the language she used similarly failed. To start, she attempts to lessen the defamatory impact of a statement that she conspicuously omit to even quote, wherein she stated, "At the end of the day, a bee lying on somebody is low down. Yes, she got hurt, and that's cool, but how did you get hurt? How? And what are the circumstances? And what after that? So B, if you think I'm finna be sitting up here boo-hooing for a B that played up in y'all face, not mine because I said her blank was lying. B, I don't. You think I feel sorry for the B? I don't. The F, a BF with my ninja, I'ma slap that hoe and whatever comes after comes after. I'm laughing because it's the way that I be cussing, but it just sounds weird coming out my mouth. Plainly, readers understand defendant to have accused Miss Pete of lying about whether she was hurt as a result of Mr. Peterson pow-powing her. Ironically, despite not quoting the post herself, defendant claims Miss Pete did not quote the entire post. Because remember, we went back and we looked at all the posts too. Referring to a 23-page transcript of a live stream she attached as Exhibit A1 to the unsworn declaration of Sharquenta Grilly. But nothing about this transcript undermines plaintiff's claims. And in any event, it is not properly considered on a motion to dismiss. Generally, courts do not consider anything beyond the face of the complaint and documents attached thereto when ruling on a motion to dismiss. In Kennedy versus Carnival Court, um, it says, let's see, while documents referenced in the complaint may be considered as attachments to a motion to dismiss, this narrow exception applies only when the contents are not in dispute. They quoted Harris versus Ivax Corp. And yeah. All right. And then it says here, Ms. Pete objects to the authenticity of the transcript exhibits because they were generated by artificial intelligence and supported by unsworn declaration. Oh, this is good because I need to do my research on the attorney that is assisting a lot Milagro in this, because even if you submit an unsworn declaration or an unverified document, you want to try your best to ensure that you get it notarized or it is a sworn declaration, especially if you're going to attach it in these pleadings. That's number one. Number two, the artificial intelligence. If you had an AI and not a live person actually do the transcript for your videos, then that is questionable as well. Because I do not, my dog's Give me a second. As such, the court should not consider them on this motion. Kazakh versus Truist Bank, a bank, it says declining to consider documents attached to a motion to dismiss where plaintiff disputed its authenticity. Even considering defendant's argument, however, she fails to show that anything in the 23 pages of the transcript alters the clear defamatory meaning of her accusation that Miss Pete lied. For instance, defendant claims the transcript shows that she was discussing an article published by NBC, but fails to explain why that matters. The NBC article is not in the record nor referenced in the First Amendment complaint. And while the transcript references the article, defendant does not discuss its contents in a way that would show she disclosed a factual basis for her defamatory assertions regarding Ms. Pete. Instead, the transcript reflects defendant disavowing the article, stating, "I hate that you lied, and that's just that. I don't give a f about that NBC article." Defendants then claims in a conclusion manner, without citing any specific passages, that the transcript reflects her discussing her opinion and conclusions based on her observations of what happened at trial. The testimony that suggested that some of the witnesses were drunk at the night of the powing, but defendant fails to show why any of these unspecified passages disclose a truthful factual basis of her statement that Miss Pete lied. At the pleading stage, the record is not sufficiently developed for the court to credit defendant's assertion that by observing certain witnesses were drunk, she disclosed facts that could lend support to her statement that Miss Pete lied. In EG, it states that factors relating to the context of the broadcasters and its audience are not before the court. This requires a more fully developed record. At this stage, the court concludes that the Schwartz complaint meets the plausibility standard for alleging false statements of fact. They also stated Zimmerman versus, but I do not know how to say some of these names. But in that case, it states where it is not clear that the facts underlying the conclusions are available to the public, such a determination is best made on a summary judgment. So what they're saying is, like, you're putting all of these, how can I say this? You're saying such things, but you're not bringing up factual or supporting documentation to go with it. But the documentation that you are bringing up or that you are providing is not fitting to a motion to dismiss. Rather, it should be attached to a motion for summary judgment. If anything, the transcript only reinforces that defendant led readers to believe that she had an undisclosed bias for saying that Miss Pete lied. For instance, the transcript reflects her stating, "So then this ninja gonna sit up there and say, why would she lie? I'm in a twilight zone. Did you ask me why Megan would lie? Like she ain't lied 11 times." Even if defendant's statements are considered opinion sounding, the sweeping language with which she accuses Miss Pete of lying implies to readers knowledge of undisclosed false facts and is thus actionable. In Null versus State Farm, it says when a speaker accuses another of lying, that accusation implies a knowledge of facts that the accused told an untruth. Even if the speaker states the facts upon which he bases his opinion, if those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact. And McNamee, it says that the statements that brand McNamee a liar and suggest that there are unknown facts that, when disclosed, will support Clemens' denials, and that suggests the statements meet the definition of defamation, go beyond a general denial of accusations or rhetorical name calling. The statements were direct and often forcefully made. There was nothing loose or vague about them. And Milkovich, if a speaker says, "In my opinion, John Jones is a liar," he implies a knowledge of facts which lead to the conclusion that John Jones told the untruth. Simply couching such statements in terms of opinion does not dispel these implications. The First Amendment complaint, likewise, sufficiently alleges that defendant made a false statement a fact in stating, "We know you a lying asshole and you have absolutely ruined Tori's life," because readers would reasonably interpret the statement as implying Miss Pete lied regarding her claims against Mr. Peterson. And I think we all can agree. Because if there are people that saying, yeah, she lied. So you telling me. So for those who are out there saying that she lied, do you have knowledge? Do you have proof that she lied? And I'm just asking a question because here that's what when Milagro stated that, that's how some people are interpreting that. Defendant claims, again relying on a transcript that cannot be considered for some reasons above, that plaintiff omits a later statement where defendant says, "You understand, you ain't a solid B in that regard. Then you lied on set. You just don't tell the truth." But that statement does nothing to alter the meaning of the statement alleged in the First Amendment complaint. Instead, defendant asserts in conclusion fashion that she made a stream of personal opinions and reactions expressed in a confrontational tone, but fails to demonstrate that her direct and forceful statement, "We know you a lying asshole," would interpret as opinion because she said, "We know," as if you had facts, but there's no facts to prove that she lied. Because we can't go back and say, well, they didn't have the weapon because Milagro has said, and it's been verified in court records, she said before, I think after the filing of the first complaint, that, oh, they are in possession of the pow pow. The same is true for her statements asserting that Miss Pete is a non-credible witness, which is an assertion of fact because readers would understand she was tying that assertion to Miss Pete's testimony against Mr. Peterson and suggested that Miss Pete lied about the pow powing. And defendant's statement that has never been a fact that Mr. Peterson powed Miss Pete and Mr. Peterson is behind bars, presumably guilty, is likewise a false assertion of fact, reasonable understood to her audience as suggesting that Miss Pete manufactured false testimony against Mr. Peterson. The First Amendment complaint also sufficiently alleges that defendant made a false statement of fact and stating, "Was Megan Thee Stallion caught trying to deceive the courts again?" So you're saying it again as if she did it the first time. Defendant claims the statement is a hyperbole, but there is nothing loose or figurative about her statement that that the statement is in the form of a question does not make it a hyperbole or not defamatory, particularly given that the question contains a factual predicate, namely that Ms. Pete had deceived the courts previously. Defendant also claims her statement is an opinion because she refers to another litigant's pleading claiming plaintiff wrongly contested venue. But nothing that litigation serves as a disclosure of a factual basis to say Ms. Pete deceived the courts again. For example, for a second time, which, given the context, readers would reasonably assume is a reference to Ms. Pete's testimony against Mr. Peterson. They stated Florida Medical Center versus the New York Post, where a reader must assume by the context of a defamatory newspaper article that reference to another implied at least 2 visits to appellant's hospital. Finally, although defendant briefly argues her statements are substantially true and thus not actionable, this half-baked argument likewise fails. She asserts that it was widely reported that plaintiff gave inconsistent statements to the police and admitted on national television that she lied about her relationship with Mr. Peterson. These assertions are beyond the four corners of the First Amendment complaint and may not be considered on this motion. To dismiss, wait, Oh yeah, okay. On this motion, they cited another case where it says a court's review on a motion to dismiss is limited to the four corners of the complaint, and they have nothing to do with the statements that are at issue, which accuse Ms. Pete of lying about whether Mr. Peterson pow-powed her, not about whether she made inconsistent statements elsewhere or lied about her relationship. Um, Let me see. In any event, whether an allegedly defamatory statement is substantially true is a question of fact, not susceptible to resolution on a pleading motion where the evidence of truth is beyond the complaint's four corners. All right, let's see what this says. Defamatory statements accusing Ms. Pete of being incapacitated are false assertion. Defendant's defamatory statements asserting that Ms. Pete is mentally incapacitated such that she is in need of a legal guardian are false assertions of fact. A printed statement which derogates the plaintiff's mental condition has been held to be libelous per se. Defendant's attempt to liken her comments to mere insults like stupid, moron, and wacko are belied by the actual words she used. What is Megan's mental status? Does she have a guardian or not? Has she been listed as a capable person? Has she ever been deemed like legally retarded? Like anything of that nature, anything of that sort. Defendant also stated that the individual named T. Ferris is her guardian and that defendant realized MTS was slow and needed one and so it made all the sense then. When defendant chose to publicize to her more than 100,000 followers the assertions that Miss Pete's mental status was deemed legally retarded and that she actually had a guardian and was slow and needed one, she impunged Miss Pete's mental condition in a way that concrete and not mere name calling or thus the unverifiable insults. Whether Miss Pete has a guardian is verifiable. You can go and you can check records and see if she has a guardian or not. In order to get a guardian, you have to go through the courts. There's nothing in the court system that showed that another adult applied for guardianship under that. That is a legal process. And whether Ms. Pete suffers from a mental condition for which appointment of a guardian is legally required is also verifiable. For example, Florida law establishes a procedure for determining whether individuals are legally incapacitated to the extent that the appointment of a guardian is legally required. I should see if I keep reading, then what I just said is already there. Something that is verifiable with mental and physical examinations. Florida statute. It says see Florida statute. A determination of whether the individual's conditions satisfy the requirements of a guardian are made only after a hearing and a court making findings of fact on the basis of clear and convincing evidence. Defendant also seeks to shirk responsibility by referencing to the statement above as speculative opinion, presumably because it posed in a series of questions. But that does not absolve her from liability. The form of the language used is not controlling, and there may be defamation by means of a question as indirect insinuation, an expression of belief or opinion, or sarcasm or irony. Cantrell versus the ABC. It says that the language defendant used is accusatory in nature and reasonably suggests the answers to the questions she raised. Let me see. Defendant likewise fails to show that any of her assertions would be understood as loose and figurative hyperbole for which no reasonable person would believe presented facts. So in all, pretty much in the motion to dismiss, Milagro was saying these are just simply her opinions, exaggerated statements, aka hyperboles. That does not mean that it is defamatory. How I said them, it just probably came off with the tone that I'm using. This is Milagro saying this in her motion. However, Megan's attorneys say otherwise. It is how you are, you're asking the question. It's not like how can I say this? You're indirectly insinuating something that is not true. You're insinuating something that can be verified. And now it is the court's duty to interpret to see if this will count as defamatory. So that's why opposing counsels or the attorneys, they go back and forth in these motions. You'll see a motion be filed, then you'll see an objection, then you'll see a reply to that objection. So it's like they're going back and forth through paperwork, and then it's reviewed by the courts, and the court will interpret the law to see, okay, in this case, is it considered defamation? Malagro's counsel is saying that it's our opinion protected by freedom of speech and that she was using hyperboles. But so far, her attorney got two things incorrect. You're citing cases that, one, you don't have fully knowledge to, and you're using it and it kind of backfired on you. Yeah. Defamatory statements accusing Miss Pete of alcoholism are false assertion of facts. Kind of same thing that they're saying. So pretty much the use of her words, drunky, like does your liver even function well? Nothing about these statements are loose or figurative or a signal of opinion. They instead mislead readers to believe that Miss Pete is an alcoholic. Rather than show otherwise, defendants then pivots to apparently arguing that her statements are substantially true by cherry picking statements out of context from song lyrics and videos that cannot be considered on this motion. So because she's saying it in a song, you saying, okay, well, she's singing about it, it must be true. Just like in that Amelia Garcia, the former cameraman, in the Second Amendment complaint, I need to see if they filed that, where he's put an excerpt of the song where she's talking about she messing with other girls, and that's actually what happened in his little incident. Yeah. The First Amendment complaint sufficiently alleges actual malice. Um, The First Amendment complaint adequately alleges that defendant made her defamatory statements with actual malice to survive a motion to dismiss, meaning in order to not get your case dismissed, a plaintiff need only plausible plead a factual basis from which actual malice can be inferred. Um let me see. In her one paragraph argument of malice, defendant gives that the fair I keep saying I want to say I don't know why I'm trying to say fair. The first submitted complaint extensive allegations short shift and erroneously asserts that Miss Pete must establish malice by clear and convincing evidence. But that is not the standard on a motion to dismiss. Um Allegations that a story is fabricated by the defendant is a product of her imagination, so is so inherently improbable that only a reckless person would have put them in circulation, and that there are obvious reasons to doubt the veracity of the informant or the accuracy of his reports sufficiently plead actual malice. All right, they cited something there. Other federal courts have found that allegations demonstrating that a defendant relied on unreliable evidence, took statements out of context, and entertained actual ill will toward the plaintiff were sufficient to warrant denial of motion to dismiss for lack of actual malice. All allegations that a defendant researched the subject matter and would have encountered evidence contradicting her assertions is also sufficient to create a factual issue as to actual malice. Here, the First Amendment complaint includes more sufficient allegations to infer defendant acted with actual malice. So let's see what she did. She knew or should have known that her statements was false. She continued to accuse Miss Pete of lying under oath about whether Mr. Peterson pow-powed her with full knowledge of his conviction. Published stories about Miss Pete that included preconceived false disproven theories as part of a campaign of misinformation and harassment. Published her defamatory statements as a hired pow pow for and as part of her co conspirator relationship with the Petersons to gain notoriety and generate profit. Made statements so far removed from reality that they are inherently implorable, baseless, and devoid of facts, and demonstrated an extreme ill will and disdain for Miss P. Taken all together, the First Amendment complaint sufficiently alleges actual malice. This talks about the deep fake. Let me see. Go through here. The definition of promote under the statute means to issue, sell, give, provide, lend, mail, deliver, transfer, transmit, transmute, publish, distribute, circulate, decimate, present, exhibit, send, post, share, or otherwise advertise or to offer or agree to do the same. That's the Florida statute. That is the Florida statute. Defendant's motion ignores key allegations of the complaint, improperly argues the facts on a pleading motion, and misconstrues the statute. For instance, defendant wrongly claims that she did not repost or share the video on her social media, did not post it on any of her platforms, that there are no factual allegations that defendant shared or disseminated the video to anyone, and the First Amendment complaint allegedly claims she only liked the video which had been previously posted. Yet the First Amendment complaint contains allegations that defendant did share the video on her social media, really, and did post it on her X page. As the First Amendment complaint alleges, when defendant hit, okay, I get what they're going with this. As the First Amendment complaint alleges, when the defendant hit the like button on the video, she caused the video to be republished and shared on her own X page under the likes tab, where the video could then be viewed and played by anyone who went on her X page. So here's a little homework. If you have a Twitter account, go like a random video, go back to your page, and go to the likes and see if that is there. I see how they did that. I see how Megan's attorneys did that. They thoroughly, hold on, I'm on my Twitter because I'm trying to see something. If I go to my page, go to my profile. All right. So it doesn't have likes. It's now called media. So wait, hold up. I lied. Oh, did they take it away? I think they took it away. So they have posts, replies, highlights, articles, and media. Okay. I don't think they have likes anymore, but at that time they did have likes. So when you hit the like button, it automatically goes to that like section, and that would constitute as republishing. That's what they did. And then to go in further to that, she instructed people to go to the like section of her Twitter page to view the video. And if they did that and they liked it, then that goes to their page, or if they retweeted, then that's considered republishing. All right, I see what y'all did there. Miss Pete's claim for intentional infliction of emotional distress. Let's see. Miss Pete is required to allege the wrongdoer's conduct. The conduct was outrageous, and the conduct caused emotional distress, and the emotional distress was severe. Um, so we already know pretty much what the First Amendment complaint said about the way that Megan was feeling. Um, the First Amendment complaint did state that the defendant's behavior was outrageous. It consisted of her Milagro conspiring with Daystar Peterson, who was convicted felon and is Megan's assaulter. Um, she spread lies knowing the facts about the trial. She employed bot accounts to attack Miss Pete and her supporters with hateful, derogatory, and malicious statements. She promoted violence against Miss Pete. The First Amendment complaint further alleges that defendant knew or should have known that Miss Pete was susceptible to severe emotional distress, and that defendant knew Miss Pete discussed her suicidal um, ideations at the trial. So it's all of this is really taking a toll. Now, whether y'all believe it or not, once again, this is standard language that we put in the complaint. However, if you never experienced this, we can't say for certain what anybody is going through. Okay, if you never been pow-powed and had people coming from you from all sides of the United States of America, online and in person, we can't say how she is feeling. We can look at all the videos that she put out or the pictures where she's smiling and stuff, but we don't know someone's true intentions. We don't live in their head. We don't be around them 24/7. Some of our closest friends, some of our family members, we will never know what's going on with them unless they tell us, or we are there 24/7 to actually see what they are going through. When I think about people who commit, I don't even want to say that word. When I hear about individuals taking their own lives, Robin Williams, um, recently a 15-year-old that my mother-in-law was telling me about in their hometown. You look at pictures and you see these people all happy. You look at videos and you see them dancing and having a good time and all of this. But in reality, they're dealing with something that nobody knows about but themselves. So we can't sit here and say that Megan ain't acting in such a manner that we want her to act. We don't know what she's going through. And that's real talk. I don't care if you're a Megan fan or not a Megan fan. We don't know what anybody is going through. So when I do see the comments, like some of them, I'll be like, dang, it could be somebody in your hometown, somebody next door to you that is going through things, and you will never know because they act on the outside. They have to put on this persona, but when they go home at night, they're contemplating on whether to take their own life. So, yeah, I just went into a whole thing because, I see this and I don't want to go because I really feel sad because of what people will say. Regardless if you don't like this girl, you just take the celebrity status, take everything take all of that out. Just her as a human being. I don't want to see anybody take their life. And then once they do, people be like, "Oh my gosh, I didn't know anything was wrong with them," or they see exactly because let you see what they want you to see. But by the fact that this lady has came out and stated how she was feeling, and people are yet still going on with the nonsense, like they really don't care, and that's not cool. That's not cool at all. Um, So all in all, she's just rebuttaling. Megan's attorney did a very, very good job of going through there and rebuttaling um everything that Milagros motion to dismiss stated. Uh Now when I did read Milagros motion to dismiss, I was on the fence. I was like, okay, it may be a possibility she does have a good case here. It's a possibility that it just might get dismissed. But now that this opposition had came and her attorney actually thoroughly went through these cases and found that two of the cases, I don't even know what that attorney was thinking about. He didn't even bother to read the outcome of the case. He just threw the case in there. There's two cases he cited incorrectly. That's embarrassing. I'm not sure if anybody's going to catch that. Um she states a claim for cyber stalking. I mean, whether you like it or not, it's considered cyber stalking. I don't care what you call it. It's cyber stalking. Um Let me see what it says. With jurisdiction firmly established, the admitted complaint states a cause of action based on cyber stalking because it alleges that defendant willfully, maliciously, and repeatedly engaged in a course of conduct that involved directly or indirectly communicating or causing to be communicated words or images using electronic communications directed or pertaining to a specific person that caused substantial emotional distress to that person and serve no legitimate purpose, and the petition must be sworn to Section 784 of the Florida statutes. Okay, so she used words and certain conduct indirectly. So even though she wasn't talking directly to Megan, she was making comments that were indirect, but still about Megan. Words also hurt. I'm here to tell y'all, words hurt. Let me get down to the let me see. All right, defendant's motion to dismiss or strike claims for attorney fees is improper. A defendant requests to dismiss or strike plaintiff's claims for attorney fees contravenes the federal rules of civil procedure, even where there appears no basis to claim attorney's fees. A plaintiff request for attorney fees is not redundant, immaterial, impertinent, or scandalous. I'm like, what? Alternately, leave to men. I'm sorry. I'll be reading this for the first time, so I'm just kind of skimming through. All right. So, in the event the court finds any cause of action lacking factual detail needed to state a claim, Ms. Peach should be permitted to leave to amend. So, they're saying if the court does come back and say, hey, um, there is a lack of detail in your amended complaint, allow them to file a motion to leave to give them time to amend that complaint and refile it. So then it will be considered a third. I mean, not a third, the second amended complaint. In conclusion, the court should deny the motion to dismiss in its entirety, and that's that. I know it's very, very long, but I wanted to get into this for you guys. So all in all, Megan's attorney has not cherry picked, but he detailed detailedly, if that's a word, went through with a fine tooth comb the motion to dismiss. And oh, it is Quinn Emanuel. All right. Yeah, I'm just looking at the signature page. So Daniel Humphrey and Olga and Mari. Oh yeah, because Mari actually was on the Zoom call with her. So their hand, okay, all right, I see y'all. So Quinn Emanuel is the ones that are assisting on this case. I'm not gonna lie, they are a very, very good law firm. It's just that, some attorneys do what they want. Alex Spiro. But the attorney did a very, very good job of going through that motion and picking apart everything that Milagro stated in that motion to dismiss. The biggest thing is that they tried to run with was the First Amendment, saying, "Oh, those are my opinions. I used exaggerated statements or hyperboles. If she really thinks that, she's any of these things, then who am I to say that she can't?" You see what I'm saying? So, the sad part is that the firm that is representing Milagro, they didn't do a good job. Now, at the time, I thought they did a good job until this opposition came out and they said otherwise. And it's not being mean, and I'm not saying from my point of view, I'm talking about from the attorney's point of view, because when they got this and they went through the motion, they noticed several things that were not in tune, that were not aligned. And so that is a huge concern. I need to go on that firm's website and see actually what areas they cover, because this may not even be their arena, because some attorneys can be really, really good in some areas of law and not others. Not all attorneys are good in civil cases. You have different type of civil cases. You have personal injury, you have such as defamation suits, you have contracts, you have there are several areas of law, several hundreds of civil law. So, from my understanding, the people who are representing Milagro, I believe that they do more of what was it? Was it prisoner rights? I don't know. And don't quote me on that. But see, that is their field. This, what they're doing with Milagro, probably isn't their field. Y'all see what I'm saying? So they're going to make mistakes as they did in the motion to dismiss, citing incorrect cases. Now, I don't know everything. I'm not too much into. I do a couple of federal cases, but I really leave that to the attorneys, and I assist where I need to. But state cases, I got that down pat. So if I was into it, I would have caught it. But hey, I don't know everything. But y'all tell me what y'all think about this. I know I kind of went astray with some things, but I do want people to just kind of put it in perspective. Look at the statues. They mentioned that one of the statues, it doesn't apply to her because she's not a media defendant. She's not TMZ or journalist from TMZ or Fox News or CNN. She is just a private party. Therefore, she can't be covered under that particular statute in Florida. So there's a number of things, but y'all tell me what y'all think about this. Do y'all think that the case may get dismissed? Y'all let me know in the comments below. Y'all don't forget to like, share, and subscribe to this my channel. Like the video. Until then, you all have a blessed night, and I will see y'all in the next one.